Once, having been sent to school wearing a dress, and the second time for expressing to his teacher that he was scared to go home and back to his stepfather's house.
Page 31, case number C348747-2, State of Nevada versus Destini Woodruff.
Morning, Your Honor. Dena, Rinetti for the state.
Good morning.
Good morning, Robert Draskovich on behalf of Destini Woodruff, who is present at liberty.
Good morning.
And Your Honor, Louis Schneider on behalf of John Woodruff, President of Liberty.
Good morning. All right. Are we all ready for sentencing?
We are ready to proceed.
We are, Judge.
Yes, Your Honor.
Okay. So let's go first. I'll ask same questions, just a couple preliminary ones. Given that Mr. Woodruff's the first case, if you could answer first, and then Ms. Woodruff, you answer after. So let's see. Mr. Woodruff, you understand you're here to be sentenced today because you plead guilty, count 1, child abuse, neglect, or endangerment, category B, felony, guilty, count 2, child abuse, neglect, or endangerment, gross misdemeanor.
Yes, Your Honor.
And let's see, Ms. Woodruff, you understand that you're here to be sentenced today because you plead guilty, child abuse, neglect, or endangerment, category B, felony. Going back to you, sir, have you had an opportunity to review and go over your PSI with your attorneys?
Yes, Your Honor.
Going back to you, Ms. Woodruff, have you had an opportunity to review and go over your PSI with your attorney?
Yes, Your Honor.
Back to Mr. Woodruff, any issues, questions, or concerns with any of the information contained? Oh, I forgot. Did you have an opportunity to go over the risk assessment with your attorney as well?
Yes, Your Honor.
Any issues, questions, or concerns with any of the information contained in the PSI or the assessment?
No, Your Honor.
Ms. Woodruff, have you also had an opportunity to go over, let's see, your psychological evaluation with your attorney?
Yes, Your Honor.
Any issues, questions, or concerns with any of the information contained in the PSI or the evaluation?
No, Your Honor.
Thank you. Going back to you, sir, are you under the influence of any drugs, alcohol, or medications?
No, Your Honor.
You, ma'am, are you under the influence of any drugs, alcohol, or medications?
No, Your Honor.
Thank you both. Does the state have the right to argue on either?
Your Honor, pursuant to negotiations in both cases, the state's making no recommendations. We do have one victim speaker, the biological father. I'd ask that he speak last pursuant to law.
Okay, thank you. And I have no preference, whichever defendant wants to go first. Doesn't matter. You look like you'll go first.
I do.
Okay, go ahead.
Actually, Your Honor, thank you. Your Honor, we're prepared to go forward this time.
Before you start, so I've reviewed both your letters and supplemental and Mr. Draskovich's as well, but Mr. Schneider, go ahead.
Your Honor, I'm sure the court has also reviewed the psychological evaluation.
Yes, both, yeah.
And it was not in last time through no fault of my client. We had done it, Judge. It just hadn't been passed yet, and so I appreciate the court's indulgence in resetting this. Your Honor, today, as the court's well aware, my client is out of guilty plea, so this is sharing some responsibility today. Your Honor, I'd ask the court to take into consideration that my client was honorably discharged from the Army, served this country. He was a forward observer. He earned his combat tab, Your Honor, in the infantry. And as a result of the service to this country, he suffers from PTSD and has been found to be disabled by the Social Security Administration. And Your Honor, as you know, I was fighting to get him into Veterans Court, and he was accepted, but this case had lingered on for a while. By the time he went back, apparently they didn't like the way he answered the questions on the second go around. They said, "Oh, you're fine. You don't need to be in Veterans Court." And it's a shame because he needs Veterans Court, Your Honor. He needs that support. So, and with that, Your Honor, I also asked the court to realize that when he was honorably discharged from the military, he served as a police officer. All of that career ended with what happened in this case, Judge. So he's paid a price, and he's here to face the consequences today.
Thank you. Mr. Woodruff, do you have anything you'd like to say?
Yes, Your Honor. First off, I would like to thank you for your time and thank the court for their time. In the beginning when all this started, I didn't know what was wrong. I wasn't in the same frame of mind that I am now. Through the teachings and the classes and the hard work and dedication to try to become a good father, I have learned a lot over these past 3 years, and I promise nothing like this will ever happen again.
Thank you. I'm going to ask a question that I very much know the answer to, but I'm required to ask. Are you a veteran or member of the military?
Yes, sir.
Thank you. Thank you for your service. Mr. Draskovich.
You know, before I address the court, Ms. Woodruff would like to address.
Yeah, either one's
Please.
fine.
Thank
Go. Ms. Woodruff, do you have anything you would like to say?
Sorry for everything this has caused. I'll do everything in my power to make it right. And I'll do everything that the court's asking me.
Your Honor has received a number of materials my office has provided. As you can see, during the last 3 years, my client has actively engaged in services. This case arose out of bad parenting, period. Obviously, I'm not mitigating or in any way trying to ameliorate what occurred. It was bad parenting. As a result, she entered a guilty plea to a Class B felony. I will shadow Mr. Schneider's comments. She too was a career police officer. She's 29. She now has a felony conviction and lost her career. I'm not asking that to in some way say, oh, that she should be treated differently. It speaks to her character and it speaks to other aspects of her life, with the exception of this case. Studies show that it's good for children to have a relationship with their parents. She'll follow any and all requirements of either this court or the family court. They've engaged in services. I spoke with Ms. Rinetti. Right now, they are not recommending a reunification, and if that in fact does occur in the future, it will begin in a therapeutic setting. I would urge the court to consider a probationary sentence given the nature of this offense. We don't have some long-term recidivist who is appearing before you, even on her second case, saying, Judge, give me a second chance. Though she will follow, as she had said, and her statements to the court were sincere, she'll follow through with any and all requirements the court imposes. She would like to have the opportunity to work towards reunification of the named victim in this case. Your Honor, I'm sure reviewed everything in preparation for sentencing today. You saw the overwhelming support. She has a number of people here in the courtroom today. They're well aware.
Raise your hands, people, in support. Good morning.
All back here.
Good morning.
They're well aware of the nature and circumstances of this case, and their support of her nonetheless, which again speaks to her character. Her bad judgment has caused, obviously, an unalterable change for the rest of her life, and it's severely impacted her relationship with her child. I would urge the court to look at this as perhaps a chance at a new beginning. Now that this case has reached or is reaching closure, I would submit that a period of incarceration would in no way act as a deterrent. It would just exacerbate this already bad situation. And given these facts and the evidence of this case, I would urge the court to consider a period of probation, the possibility of reunification provided it's recommended by the experts, and any other conditions the court deems appropriate. On that, I'll submit it.
Thank you very much. I forgot to ask you, ma'am, are you a veteran or member of the military?
No, Your Honor.
Thank you. Do we have a speaker?
I do, and there's a number of family members as well here in support of the biological father and the
Raise
child.
your hands, family members. Good morning.
So I'm going to call.
Judge, I think I'd be remiss if I didn't point out that some of the supporters are for both parties.
That's fair. I assume that, but thank you for clarifying. Thank you.
the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state and spell your name for the record.
Go ahead.
The impact from the abuse that John and Destiny inflicted on was substantial and still ongoing, but it didn't begin when they were arrested. The crimes that they have pled guilty to are not only the abuse that he suffered at their hands. Nearly a year prior to this incident, the school had called DCFS twice with concerns for his well-being. Once, having been sent to school wearing a dress, and the second time for expressing to his teacher that he was scared to go home and back to his stepfather's house. When it was time for him to go back home, he constantly expressed that he didn't want to go, that he wanted to stay. But I was unaware, and unaware why, and he wouldn't tell me. I wasn't made aware of the DCFS calls when they occurred. I only learned after the news when they were arrested. Suddenly, his unwillingness to go back made sense. Despite the warning signs, it took him being beaten and choked to finally get him some help. And still has anxiety from the abuse. The fact that the defendants were police officers has had a compound effect on him. Not only was he betrayed by his mother and stepfather, but 2 police officers. We always tell our children that they can go to the police when they need help, but this wasn't the case for me. As any little kid does, he occasionally gets in trouble. But when he does, he panics, profusely apologizes, and becomes very emotional. He's never been physically punished in my home, but immediately begins to apologize as if some form of physical and emotional punishment is coming. If I were to raise my voice, the slightest, he cowers in fear. One way he has found to cope with this is growing out his hair. He hasn't cut it since he came to my house after the arrest. He was forced to shave his head when he was in their home, and now chooses not to cut it at all. He has made some significant progress since being removed from their household, but still expresses to me that he never wants to go back there. I find it sad that he doesn't want to go to his mom's house and from the fear and the anxiety that he's faced, but it is justified. He was 2 weeks away from his 7th birthday when they were arrested and remembers everything that they done. He is very smart and has always been mature for his age. He has since told me other things that he was subjected to while in their care, and I can tell you that these are not things loving parents do. The defendants have never been held accountable for their actions, and I am asking this court to change that. I am hoping that this court had the opportunity to look in their employment records. When leaving the courtroom over these past several months, they've made an effort to smirk on their way out. They clearly believe that they are untouchable, so I'm begging this court to show them that is not the case and hand them the maximum sentence available. I fear that they do not suffer the consequences for their actions. They will be emboldened to continue them. I'm very concerned for his safety if he is to ever be sent back there. So please give my son the justice for everything he endured. Thank you, Your Honor.
Thank you. it's not often that I offer a lot of comments on sentencings. But here I feel the need to, it's troubling to the court when I review letters and assessments that you know, a lot of times with letters, I'm not sure how much the people who write those are being told about what happened. So for example, here, I don't know that people were told that this poor child was not just spanked, he was physically abused, he was choked more than once, he was forced as a little kid go to school wearing a dress. So this isn't, as many of the letters seem to indicate, simply, oh, they spanked him too hard or something like that. And so I have to take everything into account, including what actually happened versus some other version of events. And it's troubling, like I said, because people may not understand what actually happened, especially given, you know, what I see in both letters and the assessments themselves. I take all that into account. Take the lack of criminal history into account. I take what actually happened into account. I take everything into account in issuing my sentences here. Justice, community, victim, defendants, all of this into account. The facts of this are troubling and disturbing. So court is going to judge defendant John Woodruff guilty, count 1, child abuse, neglect, or endangerment, category B, felony, guilty, count 2, child abuse, neglect, or endangerment, a gross misdemeanor, a 1-day credit time served, all remain counts that were bound over dismissed, $25 administrative assessment, $3 DNA administrative assessment, submit to DNA testing, that fee is $150. Judge defendant Destini Woodruff guilty, child abuse, neglect, or endangerment, category B, felony, 1-day credit time served, all remaining counts that were bound over dismissed, $25 administrative assessment, $3 DNA administrative assessment, submit to DNA testing, that fee is $150. Sticking with the defendant Destini Woodruff. Minimum term 28 months, maximum term 72 months. Nevada Department of Corrections suspended probationary term not to exceed 3 years. Standard probation agreement and rules apply regarding intoxicants. Shall not consume any alcoholic beverages whatsoever. So no use, possession, custody, control of alcohol. Do you understand that?
Yes,
Special conditions. Shall submit your digital storage media or any digital storage media that you have access to or use, including computers, handheld communication devices, cell phones, any network applications associated with those devices, including social media and remote storage services to search. Shall provide all passwords, unlock codes, usernames, and account information associated with those items with or without search warrant by the Division of Parole and Probation or its agent. Undergo parenting classes as approved by Department of Parole and Probation throughout the remainder of your probationary period. Comply with any imposed curfew by Parole and Probation as they deem necessary. Report to Parole and Probation by close of business tomorrow. The Okay.
Is there any a condition that you wanted to is contact with child in this particular case? There is no CPS open, so this court can do nothing. It can pass that you by approval PMP through psychologists, therapists, therapeutic session once it's approved by them, or any other no contact order that this court deems appropriate.
Anything on that from Mr. Draskovich?
Yes, Your Honor, I would submit that in everyone's best interest, there's an ultimate reunification, and my client has no issue whatsoever, as I said in my argument, that through in a therapeutic session, setting and as deemed appropriate by the therapist.
So no contact with the named victim except through therapeutic setting as approved by the therapist, and that may be modified depending on the therapist's opinion. Anything else with Miss Woodruff?
No, Your Honor.
Anything else from the state on her? No. Okay, Mr. Woodruff, court. Count one, minimum term 28 months, maximum term 72 months. Nevada Department of Corrections suspended probationary term not to exceed 3 years. However, again, for all the reasons I've already mentioned, 9 months regular time Clark County Detention Center is a condition of that probation. Remanded to custody for that. Count two, 364 days Clark County Detention Center to run concurrent with his time in count one. Standard probation agreement and rules apply regarding intoxicants. Shall not consume any alcoholic beverages whatsoever. Special conditions: shall submit your digital storage media or any digital storage media that you have access to or use, including computers, handheld communication devices, cell phones, any network applications associated with those devices, including social media or remote storage services to search. Shall provide all passwords, unlock codes, usernames, and account information associated with those items, with or without search warrant by the Division of Parole and Probation or its agent. No contact whatsoever with the named victim. And then period, end of story on that one. Okay. Thank you.
Thank you.